What happens when you file a business lawsuit in Florida? Hi, I'm Jane Muir and I'm a business lawyer in Miami. When you file a lawsuit in Florida, the first thing you have to do is draft the complaint. Your complaint is supposed to be a short, plain statement of the facts that support the grounds on which you deserve relief under your claims. After you file that complaint, there's a phase of the case that we call the pleadings phase. And during that phase, the defendant or defendants may file motions to dismiss, motions to quash service, or other motions that basically point out that there are defects in your complaint. Once that's all worked out, eventually you'll get to the point where the response is an answer. And that creates a kind of bookend effect where you have your complaint that defines all your complaints against the other side, along with their answers to what you say are the facts, like admitted, denied, or without knowledge. And that's what frames the conflict between two parties. Then what will happen is you enter the discovery phase. And this is where the parties exchange information. The legal process is not supposed to be a game of gotcha, and you're not supposed to show up at trial with a surprise piece of evidence. It's supposed to be all exchanged long in advance with the understanding that the parties just need to know what the facts are so that they can come to a reasonable and logical conclusion. But what I truly find is that a lot of people involved in litigation aren't reasonable, and they're seeking for leverage, or they're just in denial about the facts of their situation, and it's very hard to settle with that type of person. However, during that phase, there is a requirement for mediation. And at mediation, an independent, neutral third party, that's usually a lawyer or a former judge, will review all your materials and the other side's materials and consider the arguments and basically try to help the two sides come to a resolution of their dispute. It sounds something like this. When you get into mediation, the mediator will say, would you like to make an offer? And if so, how much? And then they take that offer back to the other side, who might counter that offer or might come back with arguments. The goal of litigation really is resolving disputes. And 99.9% of cases do end in settlement, according to the data from the Clerk of Courts. So settlement is the most likely result of any litigation. If settlement is impossible, then we get to the point where we are either resolving the case by a judge deciding on the law by summary judgment, or a trier of fact, either the judge or the jury decides on the facts. And this is the kind of situation where one side says the light is red and one side says the light is green, and you just cannot come to any resolution on that question. Once you get that final resolution of the facts, that's what gets rendered in a verdict or a judgment. And that just tells you which side wins. It's very risky to be involved in litigation. We lawyers have an ethical duty to always warn our clients that you have a 50-50 chance of success. And every trial lawyer that I know who has genuinely tried hundreds of cases says the same thing, that they've won cases they should have lost and they've lost cases they should have won. And so it's really preferable for parties to consider that risk and come up with a reasonable solution at the point of settlement. So that's pretty much how litigation goes in Florida. And if you have a litigation matter and you'd like some advice on what to do, please give us a call.